So welcome to Lesson 2.3, Protecting Data Privacy. In your Candidate Information Bulletin, we are in the Asset Security domain. We are in Key Area of Knowledge C, which is Protect Privacy. Our topics are going to include PII protections, privacy frameworks, the OECD privacy principles, and privacy policies and statements. Privacy, as we previously defined, is the right of an individual to control the use of his or her personal information. Personally identifiable information, which is referred to as either PI, personal information, or PII, personally identifiable information, or NPPI, non-public personal information, may include discrete information such as social security numbers, financial account numbers, passwords, PINs, a driver's license number, a passport number, a medical record, an educational record, even biometric data. Those are all included in PI. There are a number of laws that relate to the protection of PI as well as the notification of a breach of PI. But you want to look carefully at each of those laws and regulations because each one may in fact define PI or PII or NPPI a little bit differently. Personal information, though, can also include our actions. So it can include, but not be limited to, our shopping habits, our search engine queries, our browsing history, our email, our location where we are, and even pictures. And this is really an expansion of the idea of privacy, that now somebody can be tracking all of those different things and really start aggregating that information. And what you see there with your shopping habits, your search engine queries, your browsing history, some email, location, and pictures, all of that can end up in a data warehouse. And we talked a little bit earlier about that privacy concerns about once things are in a data warehouse and we start mining that to look for trends and correlations, we start aggregating the data, meaning that it comes together and we can build a bigger picture than we would have if we looked at any of these discrete pieces individually, as well as the ability to infer additional information. So we earlier had talked about data warehousing, data mining, data aggregation, and data inference. Personal information may also be in metadata. We're going to take a look at metadata and see what type of information may show up that you don't even realize is there. So personally identifiable information protections. So in some cases, personally identifiable information, PI, is given special consideration and information owners have a legal requirement to protect the data. HIPAA, GLBA, and a variety of state regulations govern the collection, the use, the destruction, and the disposal of PII, as well as breach notification. The U.S. Federal Privacy Act protects citizen data collected by government agencies, and COPA, which we talked about earlier in Lesson 1, governs the online collection and the use of data for children under 13. In addition, the European Union, Canada, and Mexico have some very strict laws that regulate the use of personal information, and we looked at those in Lesson 1 as well. It's important for the security professional to recognize that these regulations all have an impact on the security controls that need to be chosen to protect this data. And as I said before, how each of these regulations and laws define NPPI or PI or PII really varies. So you need to be aware of what the regulations are and aware of what type of information you have. This is a great area where a security professional would team up with legal counsel or compliance, those other organizational roles, to get a complete picture of what needs to be done. So let's look at some privacy frameworks. Internationally, the Organization for Economic Cooperation and Development, which is the OECD, published some privacy principles that really provide the most commonly used privacy framework. They are reflected in existing and a number of emerging privacy and data protection laws. OECD privacy principles tie very closely to the European Union member nations' data protection legislation and cultural expectations. And data owners are accountable for complying with applicable data laws and regulations. And you want to always remember that you have to think local. You're acting global, but think local. So if your data is in a location that does have a privacy framework or privacy laws or regulations or customs, you will be expected to comply with those. So we're going to take a look at the OECD privacy principles because they're really instructive. They will inform us as to how we should be thinking about privacy, and they'll really give you a very good understanding of the basis of the European Union privacy regulations. So the first principle is the collection limitation principle. And this principle tells us that there should be limits on the collection of personal data, and that any such data should be obtained by lawful and fair means, and where appropriate, with the knowledge or consent of the data subject, meaning that we should only collect really what we need, that we should always be upfront and transparent about it whenever possible, that there's knowledge or consent given, and that we're always doing this by lawful or fair means. The second is the data quality principle, and this tells us that any data that's collected should be relevant for the purpose to which it's to be used, and to the extent necessary for those purposes, should be accurate, should be complete, and should be kept up to date. You know, an interesting example is you might go to your physician and you're a new patient and they hand you out a form and they're asking you for things like your social security number, which is probably a holdover from days when insurance claims were tied to your social security number, and they're not anymore. And they really have no other reason perhaps to have your social security number. Well, that would be a great example of collecting data that's not relevant for the purpose of providing patient care. The third principle is the purpose specification principle. The purposes for which personal data is collected should be specified not later than at the time of collection. In accordance with these principles, you shouldn't be collecting a bunch of data that you don't quite know what you're going to do with but think you might have a future use, and then later on say this is what we're using it for. The purpose specification principle is very clear and says right up front you should know what you're collecting it for, and you should be able to state it at the time of data collection. The use limitation principle is that personal data should not be disclosed, made available, or otherwise used for any purposes other than those specified, except with the consent of the data subject or by the authority of law. So if you collect data, you should use that data specifically for the purpose that you collected it for. Now, the only exceptions to that is if the subject says, sure, you can share my data, you can do something else with that data, or by the authority of law, you are required to provide that information. The fifth principle is the security safeguard principle, and here's where we've got that crossover between privacy and security. That personal data should be protected by reasonable security safeguards against such risks as loss or unauthorized access, destruction, use, modification, or disclosure of data. So personal data, in addition to all of these privacy principles, that organizations have a responsibility to protect that data. The sixth is the openness principle, that there should be a general policy of openness about developments, practices, and policies with respect to personal data. Means should be readily available for establishing the existence and nature of personal data and the main purpose of their use, as well as the identity and usual residence of the data controller. It just tells us that there should be policies and practices that are made available, that the subject should know how their data is being used, the purpose of their data, as well as where their data is going to be stored and who's actually going to be using that data. And the individual participation principle says that individuals should have a right to A, obtain from a data controller or otherwise confirm of whether the data controller has data related to him. So a subject should be able to say, do you have information about me? They have the right to have communicated to him or her any data related to him or her. So the individual should be able to say, do you have information about me, and what is it, and have it provided back to them. To be given reasons if a request made, and if denied, be able to challenge such a denial. So if a subject says, I would like my data, do you have data on me? Please send it to me. And the organization, the data controller says, I'm sorry, I can't do that, then they need to provide a reason, and then there needs to be a mechanism for challenging the data controller in order to require that they provide the information. And lastly, D is to challenge data related to him or her, and if the challenge is successful, to have the data erased, rectified, completed, or amended. So we ask for information, we get it, they provide it back, assuming that they haven't challenged us. We look at that data and we say that that data is either wrong, it needs to be changed, could be any kind of issues, and we either request that it's erased, rectified, completed, or amended, and that the subject should have the right to do that. And lastly is our accountability principle, and that the data controller should be accountable for complying with measures which give effect to all of the other principles, so that we hold the data controller, in this case the data owner or the organization that has the data, responsible for complying with the 7 other principles. The OECD principles truly are the basis of the European Union privacy principles, and they are embedded in a number of sort of local customs and expectations. So even in the United States, where we don't necessarily have these same privacy principles codified in law, it's really important that even U.S. organizations understand these principles and apply them locally here as well as globally. We're going to codify all of this in our own privacy policies and statements. So privacy policies govern how an organization gathers, uses, discloses, and manages personally identifiable information. Now that could be your client information, your customer information, your employee information, or your users. But if you have PI, PII, and PPI in your possession, you should have policies that govern how you're going to gather, use, disclose, and manage that information. You may also want to add in there how you're going to classify. This is why so many organizations now have a classification called legally protected, so that any personally identifiable information that you have can easily be classified and you know what the protection standards should be. In addition, many organizations have privacy statements that they provide to customers or users, and a privacy statement will generally include how and when personal information is collected, how personal information is protected, how personal information is used and if it is shared with third parties, and how to restrict the use of personal information. As a matter of fact, there are a number of regulations out there now, sector-specific regulations, that do specify that organizations need to have privacy statements and that they need to provide those to their customers. So as a recap, you really want to be thinking about the relationship between privacy and security. You want to think about the idea that privacy is the right of an individual to control the use of data and information about themselves. You should become familiar with the privacy principles, recognizing that they are used in the European Union and that you may just want to embed them in your own organization's policies, because you may in fact have customers or consumers who are in the European Union or any other nation that does have these stricter privacy requirements, including Canada and Mexico. So let's do a lesson 2.3 review. We started with talking about PI protections, PII, PI, and PPI. We discussed the idea of a privacy framework, and we went through each of the OECD privacy principles. And then lastly, we looked at what might end up in a privacy policy and what would be in a privacy statement that you would provide to your customers or your consumers or your employees. So that takes us to our lesson 2.3, Match the Meaning. The terms I want you to be really comfortable and familiar with are privacy, PI, the Federal Privacy Act, COPA, privacy statements, and in the OECD privacy principles. So take a look at the column on the right. The meanings are all mixed up like always. Put me on pause, match them up, come on back, and we'll go through them together. Okay, let's go through lesson 2.3 terms. Privacy is the individual right to control personal data. PII stands for personally identifiable information. Okay, remember, you might see that as PI, personal information, or NPPI, non-public personal information. Federal Privacy Act governs collection of citizen data. COPA governs the online collection of minor data. It doesn't mean inconsequential data, it's data about minors. A privacy statement is a description of how PI is collected and used, and the OECD privacy principles really are the foundation of global privacy laws. I would expect any of those to be referenced in your examination. So, some CISSP exam tips. One is never collect more data than necessary. That goes back to the first principle, the collection principle, is that you should never collect more data than necessary. There's no reason to have the responsibility for having to protect that data if you have no reason to use it, and it's in violation of the privacy principles. You want to remember that EU privacy laws are significantly stricter than US laws, but if you're doing business in Europe, you do need to be aware of the EU privacy laws. Definition of PI does vary by law, by regulation, by country and by custom. So what might be covered by a law or regulation or in a country or custom, what constitutes PII can vary. So it's very important that you do your research and that you are tuned to what's actually considered PII so that you are not inadvertently not protecting a piece of data or exposing a piece of data in violation of a law, regulation, or a custom. So thank you very much for joining me for this lesson, and I look forward to seeing you in the next.